Good morning. Morning. Let's go with, there's 23-00213. Is that My Shed Rental? Let's go ahead. And that, Ms. Baker, you're here on that case?
Yes, good morning, Your Honor.
Good morning. And Mr. Reed, you're here on that case?
Good morning, Your Honor. Yes.
All right. So I have this set for pre-trial today, but let me call the case and make sure we've got the right date. So on the record in docket 23-00213, that's My Shed Rental versus Laura Van Horn. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Denise Baker, P53670, appearing on behalf of plaintiff.
Good morning, Your Honor. Tim Reed on behalf of defendant Laura Van Horn, who's next to me. Thank you.
And ma'am, you are Laura Van Horn?
Yes.
All right, thank you. This is the time set. I have it set for a pre-trial. I see that before Mr. Reed's appearance in here, I denied an objection to the default judgment concerning, this was if I remember correctly, this was a rental shed that went on property, and the person who owned the property wasn't given notice of the shed. If I remember, I'm just trying to put this together, but it involved the renting of a shed by a previous owner. Is that correct? Does that sound right, Mr. Reed?
Yes.
Well, Your Honor, it appears there's an agreement to purchase it by a previous owner on that, but it was part of the property, and there's no financial statement or any security interest filed on it. And so Ms. Van Horn got brought into this because they have a judgment, I believe, against the other defendant, but can't collect from him, but she should not be a party to this case.
Right. That I just remember that it had to do with the rental of a shed. I don't remember the facts, but I remember how this case got brought, how I received the case. So Ms. Baker, where are we today?
Well, Your Honor, I was unaware of any appearance by an attorney, and we have no answer filed by the defendant, Laura Van Horn, either. So if we could get copies of those documents, we are proceeding with this action against Ms. Van Horn, as the property owner on which the shed sits. Mr. Kemmer, who is the other party to this action, is the one that contracted for the rental of the shed. And then it's my understanding that the property was sold to Ms. Van Horn, and the shed is located on her property. So our action against her is for possession of that shed.
Right. And then Mr. Reed, you filed your appearance on July 19th. Is that correct?
That's correct, Your Honor, and I put it in the mail as stated to the attorney of records.
Right. And Ms. Baker, are you covering, or are you a part of Mr. Renner's office?
I am with Mr. Renner's office.
All right. So so at this time, we have a new appearance. This case has kind of a history in regards to the filing on the previous. So I think that So Ms. Baker, have you had the opportunity to speak with Mr. Reed, or you probably have not because he filed his appearance. I can reset this for a pretrial. So we actually fill out a pretrial statement. I have this set for pretrial today, but the parties haven't met or spoke. And since we have an appearance from a new party, it appears that you'd at least like to fill out a pretrial conference schedule. That would be my guess, Mr. Reed.
Yes, Your Honor. We can do that, and I can get with Ms. Baker or Mr. Renner.
All right. So let's do that. Let's do we set the pretrial or do they? Yeah. Let's set a pretrial date, and then I'm going to give the parties, that time to speak to one another. That would probably, we could do it today. I could put you in a room today, but they're on Zoom and you're here physically. I guess we could put you on an iPad, but it would be, we could do it that way, or we could allow the parties to talk and I could give you a date. But I'd like a pretrial date.
Yeah, another day would be fine, and we'll get the pre-trial statement in, so we probably don't have to appear.
Okay, and you can either get each individually send in a pretrial statement. If I have any questions, I'll give you. I can have my office contact you, or we can get on a date and just do it on the record. Either by Zoom with everybody here. Either way is just fine with the court. But let me get a new pretrial date.
August 7th at 8:30.
So we'll do. Does August 7th at 8:30 work with both council schedules?
No, Your Honor, I'm out of town that week.
All right, let's try. Yeah, August is it's shocking how many lawyers take August off, including judicial conferences are also in August. We could go to, that's August. And I'm at a judicial conference on the 21st and vacation the 8th. We could go try the 4th, September 4th.
September
Ms.
4th.
Baker, does that work with your schedule? It would be September 5th at 8:30. It'd be a Tuesday instead of a Monday. Yeah, there's that Labor Day holiday that's a problem. Yeah. So does September 5th work for the attorney schedule on that?
That works for plaintiff, Your Honor.
Okay, I'm gonna indicate that Mr. Reed filed an appearance for defendant, and we reset for pretrial for September 5th, 2023. What time? At 8:30. And that should give the parties some time to talk. And then we can either fill out a pretrial statement on that day, or I'll entertain any pretrial statement submitted by the parties. Okay. Anything else for the record in docket 2300213? Ms. Baker?
Yes, just wondering what Mr. Reed's first name is, so I can note our account too.
It's Patrick. If I remember correctly, it's Patrick. Is that correct?
Yes.
Yes.
And then also, has an answer been filed?
So answer was filed in May by the defendant, and I'm going to be filing an amended answer.
All right, that's all for the plaintiff. Thank you so much.
And anything, Mr. Reed, concerning this file?
No, Your Honor, thank you, and have a great week.
You too. Thank you.
Thank
That's
you.
all set. You're all set on this file, Ms. Baker. Thank you, Mr.
Yes.
Reed.
Thank you.
Thank you.
Mr. McKee, right? And Ms. Williams, how are you? I know your name. All right. Is there a representative of Credit Acceptance Corp?
Yeah.
Is that you, sir?
Yes, sir.
All right. What's your name, sir?
Alfonso Nixon.
Okay, Mr. Nixon, why don't you come on here and have a seat? And is there a Latoya Flanagan? Ms. Robinson.
Good morning.
Good morning, Ms. Robinson. All right, so we're on the record in docket 14-00828 GC. That's Credit Acceptance Corp. Versus Latoya Flanagan. Will the parties please introduce themselves for the record?
Alfonso Nixon representing Credit Acceptance Corporation, Your Honor.
So it's Alfonso Nixon. And this was scheduled for 8:30. It is now 8:50. Is there a Latoya Davis Flanagan? And I don't see anybody in the Zoom courtroom. Is there a Latoya Davis Flanagan in the Zoom courtroom? But then you might want to call just in case, because this is based on her motion, isn't it?
It is.
Yeah. Just in case she's sitting down or somewhere on the floor.
Technology can be deceived.
Yes, absolutely. All right. So this is the time set. So it's now 8:30. It was set for 8:30. It's now 8:51. And it would appear that Ms. Flanagan has failed to appear. And if I understand this correctly, this was a motion to set aside or a motion to set aside based on installment payments. Ms. Flanagan wanted to make installment payments. But if I remember correctly, I'd previously set aside a denial on this case and then indicated that it was that at least that portion of it was closed. And then is this a new one? All right.
She filed another, it looks like the defendant filed another one, like a few days, I think, after the prior.
Right. And if I remember correctly, and civil is certainly not my strong suit, but she has to wait 91 days before she can file anything immediately after. Well, that's all put on the record. But how would you like to proceed, Mr. Nixon?
Based on defendant's failure to appear, I ask the court to deny her motion.
The DFDPA, the motion to set aside order installment payments. Because of defendants failed to appear. So I'll deny the motion to set this installment for $200 for various reasons. One, the defendants failed to appear, but I'll also place two, that the motion was filed immediately after my last ruling. So within 91 days. All right. So would you like to follow up with an order to that effect, just denying the motion?
Yes.
Okay. If you follow that order, then we'll put on, because I have a tendency to forget about it, and then if it's an order for default judgment is not put in, I have to remind myself to do an order from just to close the file or close this portion of the file.
We'll file it.
Perfect. So I'm going to put order to follow by plaintiff. Anything else on the record in 1400828, Mr. Nixon?
Not from the defendant.
All right, thank you. That's all for the record in this file. Well, as a matter of fact, right here, I have a motion. This is on her first one, though. I'll just put motions denied on here, okay?
Okay,
All right, so that should take care of everything.
okay,
All right, thank you.
thank you.
So these candy motions are in the file already. That's very helpful. We'll sign that. Is there a representative of Twin Oaks Meadows?
Yes, Your Honor. Todd Bronson.
Is that you, Mr.? All right. That's 250. And then is there a Kenneth Blackman? Okay, Mr.
Sure.
Blackman, you can come up here.
Morning, Your Honor.
Good morning. All right. Parties' appearances for the record, Mr. Bronson.
Todd Bronson, on behalf of Twin Oaks, Your Honor.
Thank you. And sir, you are Kenneth Blackman?
Yes, sir.
All right. This is the time set for a motion to stay an eviction, which was granted after a conditional dismissal. Is that correct, Mr. Bronson?
Yes, Your Honor.
All right. And Mr. Blackman, so I understand this correctly. You entered into conditional dismissal, and then May went by, June went by, and then you did a motion to stay that conditional dismissal, that order?
Yes, sir. But Mr. Bronson owed me money. I've done work for him. I haven't got paid for.
Was that part of the initial conditional dismissal?
No, they didn't include none of that.
All right, Mr. Bronson?
Your Honor, it was. We did provide a ledger to the court via email this morning as well as last week, if you happen to have that in your file. The ledger indicates numerous work credits on behalf of Mr. Blackman, so he was compensated for any and all work that he did. In addition, we have our property manager for that one, Mr. Reed, on here as well, who can testify to the same.
Oh, that's why Mr. Reed's here. Okay, so Mr. Reed's a property manager on this?
Correct, Your Honor.
All right.
And he's the one who had most of the dealings, if not all the dealings, with Mr. Blackman regarding work to be performed.
All right, but Mr. Blackman, this is based on any conditional dismissal, you have time afterwards to say that it was somehow ambiguous or you didn't understand it. but I didn't get your motion till July 12th, which is well after the April 5th date.
Yes, I understand. Your Honor, I did work for Mr. Bronson in Saginaw.
And
on
what?
I did work for his property in Saginaw. I haven't received funds on that
When did you do that work?
in December.
Right. And you signed a conditional dismissal in April, April 5th.
I'm not with that knowledge.
But I have in my notes that there was a consent order and dismissal on April 5th. Mr. Bronson, do you have that same? I have a condition. I think in this file, I have the conditional dismissal.
You should, Your
That
Honor.
the conditional Go ahead,
I
Mr.
would
Bronson.
also mention that Mr. Blackman's motion came after we attempted to execute the writ. It was posted on his door. That is when he went down and filed his current motion, so he had more than ample time to respond to any consent order issues.
Yeah, I have the consent order or conditional dismissal. I have your signature on mine's on April 5th. You signed I've got at least May 4th on here.
There you go.
That you signed it. So I'm a little confused as to after the fact now, 3 months later, you're going back and saying, set that conditional dismissal aside. I didn't get paid for work in December.
Oh, exactly. I'm not court literate, but I'm listening.
Okay, but court literate just means we signed an order and we abide by that order. And months later, you're saying I don't like the order because something else was not sent to me in December. Does that? I guess I'm a little at a loss as your motion to set aside in July 12th for something you agreed on in April.
I'm lost. Do I need to get a lawyer?
You probably, yeah, I do, but I think you're probably gonna hear some of the same information from the lawyer that you signed an order and for a conditional dismissal, and
I paid that. You talking about the 700 and?
Yeah, but that's not what you're asking to set aside. You're saying that you're owed money now.
Yes, he does owe me money.
But you already signed an order. You already signed an order saying that if it was for $732, defendant shall pay the total amount stated above on or before. In addition, defendant may bring 2023 rent current within said 30 days. That was the nature. Mr. Bronson, am I missing something? That was the nature of the conditional dismissal. Is that correct?
That is correct, Your Honor, and those payments were not made.
And that was signed by yourself, and then now in July, you're saying disregard that, the plaintiff owes me money.
Yes, sir.
Well,
I'm just here because I didn't want to miss a court date, but.
Well, this is your motion. We're here on this is your motion to set aside the verdict. I mean, we're here because you said I have paid the $732.
Yes, sir.
And Mr. Todd Bronson owes me money for work I did in his building.
Yes, sir.
Okay,
And both of them. He gave several properties.
But then after the fact, you consented that this payment was the amount of payment that was owed.
Yeah, I paid that. The $758. Is that what you talking about?
It's your motion. So the motion to set aside possession judgment. Okay, that's your motion. You signed it, and then we're here on that. And it was stayed by Judge Ward. Okay, Judge Ward stayed it, and we're here present. And now the eviction was motion to evict granted. Contract Ramsey Court Office not to serve order of eviction on July 12th. And then we're here on July 24th on your motion. And you're indicating that I should put the consent judgment that you signed aside.
I'm not smart like that, sir.
Okay.
Just-
Well, I'm just trying to figure this out, sir.
Yeah,
Okay.
me too. I mean,
You signed a consent judgment. You remember that on April 5th? You signed that document. You signed this consent judgment.
yes, I remember that.
All right.
And I paid that off.
All right. And so I have that document, and now you want me to set that document aside.
Well, I mean, I don't know what to tell you.
Okay. All right.
I need a lawyer.
All right. Mr. Bronson, I'm assuming you're objecting to the motion, so I'll let you make a record.
Yes, Your Honor, we're objecting to the motion. It's definitely not timely. The funds were not paid. We did submit a copy of the ledger through the email showing that any and all payments that were due Mr. Blackman were in fact credited or paid via his ledger towards his rent, and that there's still a balance due of rent in the amount of $1,573.75, and that does not include legal costs. So we would ask that the court deny the motion, Your Honor.
All right. Well, after hearing the evidence and seeing the motion, and I'm going to deny the motion to set aside possession judgment. So, motion to set aside is denied. And the original conditional dismissal is, and if I understand correctly, the conditions of the conditional dismissal were not met, so you asked for the case to be reinstated. Is that correct, Mr. Bronson?
That's correct, Your Honor, and I believe those were entered, which allowed us to go forward with proceeding on writ.
So the motion to set aside is denied, and the case is to go forward on conditional dismissal, which was the conditions were not met.
Correct, Your Honor.
So just, Mr. Blackman, we're right back where we started. The order's in place, the conditional dismissal was not met, and it looks like the order of eviction was signed on July 7th. Is that correct?
Yes.
That was by Judge Ward. And then on July 12th, it was, so that July 7th, order is still in place, okay? That initial order is still in place. What's the time period for that, Mr. Bronson?
We've
Because I
already
think we're past.
Yes, we've already posted, Your Honor. He was supposed to have been out within 24 hours, and then he filed the current motion in front of Your Honor.
All right. So let's get a date. Let's get a date to make sure that you're out of the placement. Mr. Bronson, can your client? This is the 24th. I want to make sure that everything's out, right? Yeah, and I want to make sure that we have necessary time. I mean, Mr. Bronson doesn't want to deal with your stuff on the side of the road. You don't want to deal with your stuff on the side of the road. Can you be out by this Friday, the 28th?
I'm gonna have to.
All right.
Can I get more time?
It's that's the time frame I'm willing to give you is 28th, unless Mr. Bronson believes that his client can give you more time.
I think we like your date, Your Honor.
I can give you 1 week.
Okay.
1, 2, 3, 4,
Thank you,
5,
Don.
6. So how about by 5 on the 31st? That'll give you the weekend also.
Thank you.
All right. So let's do to vacate property. So defendant is to vacate property by July 31st, 2024. And we'll make it at 5 o'clock, okay?
Thank you, sir.
Okay. 2020, what did I say? I didn't mean 2024. That seems like a long time. 2023.
23.
Yeah, 2023 at 5 o'clock. And the property, property should be vacated by that time, all right?
No problem.
All right, Mr. Bronson, are you all set on 23-00250?
We are, Your Honor. Thank you and have a good day.
You too. Thank you, sir. You're all set. And I don't think I have to do anything else because I denied the motion. I will indicate for the record that I denied the motion, and we might have to do a motion on this to make sure that it's denied. Yeah. I'm gonna put a star on this one. It said denied. Yeah. Mr. Reed, you're free to leave then, okay, sir?
Oh, you talking to me?
Yeah, you
Hello?
were here on Twin Oaks.
Yeah. Actually,
right.
I was going to ask Mr. Bronson, what was the date that you gave again?
Okay, Mr. Bronson left, but I can tell you it's Monday, July 31st. So it's a week
Okay.
from today at 5 o'clock.
Okay, I thought you said 21st.
All right.
All right, thank you.
So you're all set, Mr. Reed.
Appreciate it.
And then we're on the record in 23-01076. That's portfolio recovery versus Nicholas Deegan.
Good morning,
Will
Your
the
Honor.
parties please introduce themselves for the record, Ms. Richter?
Good morning, Your Honor. Christine Richter for the plaintiff, P61525.
All right, and is there a Nicholas Deegan? Is that you, sir?
Yes,
All right. I have this set for a pre-trial this morning. Have the parties had the opportunity to meet on this case at all, Ms. Richter or Ms. Deegan?
No, Your Honor.
Would you, generally, this is the time set to fill out the pretrial statement, but I would extend to place you in a breakout room, Ms. Richter and Ms. Deegan, if you wanted to talk about the case.
Oh, okay.
Happy to do, Your
sure.
Mr.
Yeah,
Deegan, would you be amenable to that?
yeah, absolutely.
All right, so I'm going to have Ms. Richter and Mr. Deegan placed in a breakout room, and then we'll come back and place whatever we need to on the record, all right?
Thank you.
Sounds good.
All right, thank you. So we'll adjourn at that time, and you should get a prompt to go to room 2?
No.
Room 1. You should get a prompt to go to room 1.
Okay.
Lamari Adams, would you please indicate what case you're here on? Lamari Adams?
Yeah, I'm here. I believe it was today for my rent.
Oh, you're here. Are you here for your 10 o'clock
Okay, it's at 10
with
o'clock.
on a landlord tenant matter?
Yes, okay.
All right. You are in the right courtroom. You're scheduled for 10 o'clock today.
All right, I'll be back.
All right. Mr. Staples, are you here on Property Ventures?
That's correct, Your Honor.
All right, let's go ahead and go. Let's call that case forward then. All right, so we're on the record in docket 23013401. That's Property Ventures. That's a zoning compliance review. And we have an attorney here who's indicated he has not filed an appearance. You plan on doing that, sir? Is that correct?
I do, Your Honor.
All right. So let's go ahead. This is set for a review hearing. I do have that. It looked like Property Ventures. Now let's go ahead and put it on the record. So we're on the record in property in the 23013401 Property Ventures, City of Lansing versus Property Ventures or Property Ventures of Michigan LLC. Mr. Staples, your appearance for the record.
Matt Staples, Assistant City Attorney for the City of Lansing.
All right, and then Mr. Driver, you're also here on this case.
That is correct, Your Honor.
All right, and I'm assuming that you wrote the ticket.
Yes, sir.
All right, and then counsel, your appearance for the record.
Edward Christensen, number 58192, on behalf of Property Ventures of Michigan.
All right. Edward Christensen, and did you say your fee number again?
58192.
Okay, 5819. And then, sir, what is it? You're the representative of Property Ventures of Michigan, is that correct? And what, Nathaniel, how do you say your last name?
Markovich.
Markovich.
Yeah, that's Andy.
Okay. I have this time set for a review hearing. I'm assuming they called it that because they didn't know what else to call it on some level. Mr. Staples, how are we proceeding today? This is what I have. I have that on June 15th, there was a code compliant show cause to July 3rd at 9 a.m. At the show cause on July 3rd, the defendant would fail to appear. So the city would follow up with a 7-day order from the city And then based on that order, it's been reassigned by the civil department to July 24th, 2023. Mr. Staples, how are we proceeding today?
Your Honor, Mr. Driver sent me pictures this morning showing that the containers listed in the original ticket and complaint remain on site. And therefore, the city would request that the court authorize a fine in the amount of $500 for failure to have remedied that violation at this point.
All right, and this is actually the first time that Property Ventures of Michigan and that they've appeared. Is that correct? On some level? All right. Mr. Christensen, how do you respond?
Your Honor, this property is the old bowling alley Metro Bowl over on MLK. It's been in ill repair for a long time. It's not functional. Mr. Markovic and his company bought this property to rehab the inside of it and hopefully sell it to something else. There are approximately 10 semi-trailers on the property and a number of dumpsters as well. The dumpsters don't contain any materials. They may be containers, but they're owned by Lansing Recycling. They don't do any recycling on the premises, Your Honor. It's not a functional building. So they merely pick up trailers from that location, take them to other places, do whatever they have to do, bring the trailers back. It's merely, for want of a better word, the dumpsters are just merely there for storage purposes for Lansing Recycling. As far as the semi-trailers, there are building materials that relate to the tear out and the siding repair for the location. And Mr. Markovic and Property Ventures does have a permit, although, I mean, at one point it was expired, but it has been since renewed. So there are certain materials that are in the semi-trailers, but they're related to the tear out. So at this point, I don't know what the violation would be, because the dumpsters don't have any material in them, and semi-trailers have building materials that only relate to the tear out and siding.
Well, let's do this. Mr. Staples and Mr. Driver, would you be amenable to speaking with Mr. Christensen in a breakout room concerning, this is the first time I think the parties have all gotten together on some level.
I would be more than, I haven't had a chance to talk to Mr. Staples, and I would actually prefer that.
Yeah, rather, at least, I mean, we're looking, at least you got all the parties here. So Mr. Staples, would you be amenable with Mr. Driver in the same breakout room to speak with Mr. Christensen and his client to see if we can resolve this, or at least to set it for a pre-trial with some timeout, because it looks like some things might be contested in this matter.
Yes, Your Honor, that would be fine. I believe Mr. Driver can explain why the ticket was issued and the zoning issues with the property owner. So that would be a great way to move forward, Your Honor.
All right, so why don't we do this? My court officer is going to put you on an iPad with your client, and then we'll set it all up. So follow him when he comes back, because I think he just went to go get the iPad. Okay, and what we'll do is once we set you up, we'll place everybody in a breakout room, and then we can come back and put it on the record. All right.
That's great.
All right. Thank you. So, Mr. Staples and Mr. Driver, we're going to place you in a breakout room once we get everybody all set up. Okay, sir?
Sounds good. Thank you very much, Your Honor.
All right. Thank you. All right, so Ms. Richter, you've had the opportunity to speak with Mr. Deegan in a breakout room on docket 23011076.
Yes, Your Honor.
And did you want to place anything on the record that came out of that meeting? Or we can just go ahead and fill out the pretrial statement?
Your
Or
Honor,
what we
the
can.
parties did reach a resolution.
All
The
right,
parties are going to execute a conditional dismissal with payment terms. Mr. Deegan will pay the balance of the principal debt with it, which is $2,722.18. He will make monthly installment payments of $100 per month until that balance is paid in full. And I just realized, Mr. Deegan, I forgot to ask you what day of the month you want those payments due.
Oh, maybe like at the beginning.
Beginning, okay.
Like the first, yeah.
So then we'll say the first payment will be due September 1st.
Yep, that sounds good.
Okay, and then it'll just be the first of each month thereafter until that balance is paid in full. And as I indicated to Mr. Deegan, in the event that payments were not made according to the agreement, my client would have a right to file an affidavit of noncompliance, which would allow the court case to be reopened and a judgment entered for the remaining balance of that debt, with court costs being added back into the balance.
okay. And that's your understanding, Mr. Deegan, of the agreement that you just made in relation to this is an accounts doable complaint, if I'm correct, right, Miss Richter? This was the out of Synchrony Bank.
That's correct, Your Honor. It was a B&T photography credit account issued through Synchrony Bank, and my client purchased the debt after it was charged off for non-payment.
All right. And Mr. Deegan, just so I'm covering bases, you understand that you're entering into this conditional dismissal in the terms of this installment plan. You don't have a lawyer today, and so you understand that. I don't know how. I don't know, but you've got several days after the fact to say that you didn't understand, or this is somehow ambiguous to you. Although it seems fairly straightforward that you've entered into an installment plan. Do you understand that, sir?
Yes,
All right.
absolutely. I think everything that we came to is fine.
Was anything discussed in the breakout room with the attorney? Anything placed on the record different than what you heard in a breakout room?
No.
Okay. So, Ms. Richter, I'm assuming you'll either have Mr. Deegan review the document and then forward it to me, or Mr. Deegan can authorize the signature of the document on it. Either way, as long as Mr. Deegan understands the nature of what he's agreeing to.
Yes, Your Honor. Typically, my client likes to send that agreement out to the customer so that they can review it.
I'll say, okay. So the court will await the order to follow concerning the installment plan. And then if I have any questions, I can contact you, Ms. Richter?
Yes, Your Honor.
All right. All right. So anything else on the record in 23011076, I will await the order and the installment plan to follow. Anything else, Ms. Richter?
No, Your Honor.
All right. Mr. Deegan, do you have any questions of me?
No, Your Honor. Thank you very much. And thank you, Mr. Richter.
All right. All right. Thank you. That's all for the record in 23011076.
Thank you. Thank you, Mr. Deegan. Have a
Thank
great
you.
day.
Thank you too. You too. Bye.
And then Mr. Kasser, are you ready to go on? By the way, it's nice to see you, sir.
Good morning, Your Honor. Great to see you again.
So, and you're with your client, Mr. Hamill, is that correct?
We are, Your Honor, and we are ready to proceed.
All right, let's go ahead and put yours on the record. All right. Let me find that. Let's see, 230201. All right, Ms. Williams, you're here on that file?
Yes.
All right. So we're on the record in docket 23020015. That is the City of Lansing versus Rhett Hamill. Will the parties please introduce themselves for the record? Ms. Williams.
Good morning, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
And Mr. Kasser?
Good morning, Your Honor. Raymond Cassar on behalf of Brett Hamill, who's present with me in my conference room and consents to this hearing over Zoom, Your Honor.
Thank you. And sir, you are Rhett Hamill?
Yes, Your Honor.
And you can hear me all right, Mr. Hamill?
Yes, I can, Your Honor. Thank you.
All right, thank you. This is the time set for a pretrial, City of Lansing pretrial. Ms. Williams, how are we proceeding at this point?
Your Honor, I sent a communication to Mr. Cassar last week, but I have not heard back, so I would like to defer to him on how he would like to proceed this
All right.
morning.
Thank you, Mr. Cassar. How are we proceeding today?
Thank you, Your Honor. Your Honor, the assistant prosecutor is correct. I did send a mitigation letter out to her. She was unable to reduce the charge. She has made a tentative offer of no upfront jail, a tentative offer of no upfront jail, if the court allows it. At this time, Your Honor, I've advised my client of his right to a trial in this matter. We've reviewed all of the discovery materials. He wishes to tender a plea to the resisting and obstructing a police officer. However, we are asking the court to consider taking the matter under 771.1.
Ms. Williams.
If Mr. Cassar would like to speak in private, we can try to work out an agreement.
All right. Well, it looks like there's an agreement. Ms. Williams says she can talk to you about that. So let's start there and we'll work from there. I mean, that probably is because yeah, let's start from there. But I think the iPads can you get in?
Yeah.
So, Mr. Cassar, would you be amenable to meeting with Ms. Williams concerning the pretrial, just so you can talk a little bit more about this, and then she's going to join on her laptop, and I'll place you in a breakout room with you and your client.
Of course, Your Honor.
All right, thank you. All right, so once you join, we'll put you in.
I'm ready.
Okay.
Yeah.
Are you in?
Yep.
You sure are. All right. So you should get a prompt to go to room 1, and Amani, you'll be in room 1.
Thank you, Your Honor.
Thank you. Ma'am, on the Motorola cell phone, would you please identify yourself?
Catherine Ann Cliff.
So it's Catherine Antcliffe, is that correct? You're here for your 9:30?
Yes, correct.
All right. Ms. Antcliffe, I'm going to place you in a breakout room with your public defender so you can talk about the case, all right?
All right, thank you.
All right. Ms. Robinson, I'm going to move you just for a second. Yeah, just so we can move this file.
Sorry about that.
All right,
No,
no, you're
you're
good.
okay.
All right, so we're back on the record in Property Ventures. That's 23013401. And Mr. Staples, you have the opportunity to speak with Mr. Christensen in a breakout room.
That's correct, Your Honor. At this point, we would request that the court give us 30 days. We're going to have an inspection done on site with Mr. Driver, a building safety officer, and the owner so that they can explain to him the violations and he can explain to them their side of it, and we can kind of get a basic set of facts to go off of, Your Honor.
Okay. Is that correct, Mr. Christensen?
Absolutely is, Your Honor.
So we'll set out for 30 days, but I'm just warning, it'll be around 30 days because it's been my experience that it appears that every lawyer I know takes August off, or it seems that way on some level. So let's get close to that 30-day mark, which is what we're trying to do, and not disrupt everybody's schedule. Is that a September 5th or September 4th?
August 21st.
Does August 21st at 9 work?
I believe it. I turn my phone off when I come into a court.
All
Your Honor.
right.
So, but I believe 21st sounds great.
Mr. Staples, for the city attorney's office, August, does that work? August 21st?
That should be fine, Your Honor.
All right. So let's set it for August 21st at 9 o'clock for a second I will just call it a pretrial. Now that we have all the parties, and also to give some time for, my understanding is the parties to meet out at the site and the city of Lansing to go out there and explain some of the ordinance violations and then some of the response pursuant to that. And then we can meet on that date and see where we are. Okay.
Yeah, sounds perfect.
All right. All right. So August 21st at 9 a.m. is the date. Anything else for the record from the city on Property Ventures?
Nothing from the city, Your Honor.
All right, Mr. Christensen, anything else?
I'll get my appearance in.
All right.
That's it.
All right, we're all set. Thank you for your appearance today.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
All right, let's go back on the record in docket 23-02015. That is City of Lansing versus Rhett Hamill. And Ms. Williams, did you have the opportunity to speak with Mr. Kassar in a breakout room?
Yes, Your Honor.
Just to make sure we were all on the same page. How are we proceeding today?
Your Honor, I would like to adjourn it for 30 days for compliance purposes.
Okay. Mr. Kassar, is that your understanding? We're going to adjourn it for 30 days for compliance purposes?
It is, Your Honor, correct. I appreciate Mr.
All
Williams.
right. All right. So at this time, we'll adjourn for 30 days for compliance. And let me give you a new date. And once again, we're trying to get 30 days out, but it seems August is a real popular month. So does that August 21st at 9 work for your schedule, Mr. Kassar?
Your Honor, no, Your Honor, I'm in another court. Is there any way that we could do it on the 23rd, Your Honor? Is that possible? Or the 22nd? Preferably the 23rd? Or the 24th?
Yeah, it's got to be on a Monday because the city attorney has to be here. And the city attorneys, so could it be on the, so what Monday would work for you? And I can set it on the, we've gone out to the, we did the 5th because on
the 14th, Your Honor, is a Monday. We could do it on the 14th.
On August 14th?
Yes, Your Honor.
I don't know if that gives enough time for compliance, does that?
We can confirm with his client.
Is that enough time for compliance purposes?
Oh, no, Your Honor, unfortunately, you're right.
That's all right because they just told me we're running a murder prelim on that date, so that would probably not a good idea.
Your Honor, what if we did? Is there a later schedule, Your Honor, that we could do it on a Monday? Can we do it late?
We could do it on the 11th.
The September 11th, Your Honor, is that what you?
Yeah.
It's wide open, Your Honor. Yes. Works.
Perfect.
Thank you, Judge.
Let's do it. Let's do it at September 11th at 9 a.m. And Amani, I know where you'll be.
I'm not sure where.
Well, I know Mr. McKee here will have a replacement. Is that right around your date?
Yes.
Yeah. So yeah, we might lose. We'll have a city attorney here, and we'll make sure that they're communicated with and with all the relevant information. But we'll set it for 9/11 at 9 a.m. All right, Mr. Kassar.
Your Honor, it was a pleasure dealing with both Ms. Hamill or Ms. Williams and yourself. Ms. Williams, if you would just put a note in the file, that way, if you're not there, perhaps the next person that will pick up the file will understand what we discussed.
I will make sure of that. Yes.
All right.
Thank you so much.
Thank you, Mr. Kassar. Have a good one.
Great to see you again.
All right.
Thank
Take
you,
care. So we're on the record in docket 21 L2648612. That's the City of Lansing versus Catherine Antcliffe. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the City of Lansing requesting permission to practice under MCR 8.120.
All right, that's granted, Mr. McKee. Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Ms. Antcliffe for today's pretrial conference.
And ma'am, you are Catherine Antcliffe?
Correct.
All right, and you can hear me all right, Ms. Antcliffe?
Yes, I can.
All right. This is the time set for a pretrial today. Mr. McKee, how are we proceeding?
Your Honor, the city would move to dismiss at this time.
No objection.
Okay, so the city moves to dismiss without prejudice, and that, of course, is without objection. So, Ms. Antcliffe, today the city is dismissing this case without prejudice, which means that the city could reissue if they choose to. It's unlikely, but they could. But for our purposes today, the case is dismissed. All right, ma'am?
Okay, thank you.
All right. Anything else for the record in docket 21 L2648612? Mr. McKee from the city.
Nothing further, Your Honor.
All right, Ms. Sutter, anything else?
Nothing further, thank you.
All right, you're all set. You're all set, Ms. Antcliffe. You can leave the Zoom courtroom.
Thank you.
Then we have,
Mr. Pruitt is the one in custody, if you want ready.
yeah, let's go ahead, Mr. Pruitt. Since we have him here. All right, so we're on the record in docket 23-02061. That is the City of Lansing versus Samaj D'Angelo Pruitt. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the City of Lansing, practicing under MCR 8.120.
And Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Pruitt.
And sir, you are Saman Pruitt?
Yes, sir.
Okay, and you can hear me all right, Mr. Pruitt?
Yes, sir.
All right, thank you. This is the type set for a pretrial in the City of Lansing matter. Mr. McKee, how are we proceeding?
Your Honor, it's my understanding that the defendant will be entering a plea to an amended charge of no ops with time served. That is MCL 257.311.
And no ops has it's 90 days and or $100?
Yes.
And there's also a Killebrew agreement of time served.
Yes, Your Honor.
And is that an accurate statement, Ms. Robinson? It's my understanding the defendant's going to plead guilty to amended count of 257.311, no ops in possession, that's 90 days and or $100. And there is a Killebrew agreement of time served.
That's correct.
All right. And that's your understanding, Mr. Pruitt?
Yes.
All right. Mr. Pruitt, this is a misdemeanor, so I'm going to walk you through some of your misdemeanor rights in this case. You understand the maximum penalty that is potentially available to the court under this license. This is a license, a ticket would be 90 days and or $100. Understanding there is a Killebrew agreement of time served. If I was to go over that agreement, you could withdraw your plea. Do you understand that, sir?
Yes.
All right. So in this misdemeanor file, you have the following rights. You have the right to be tried by a jury, to be presumed innocent till proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses brought against you. You are represented today, of course, by Public Defender Aaron Robinson. She would be here to contest any charges or cross-examine any witnesses brought against you by the City of Lansing. You have the right to have the court order any witnesses appear in your defense. You have the right to remain silent, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was the result of any promises or threats, that it was not your choice to plead guilty, other than the indicated plea agreement, and you'd be giving up the right to appeal any issues at trial. Since you won't be having a trial, you're pleading guilty instead. Is it your intention and your decision today to waive your rights and to plead guilty in this matter?
Yes.
All right. I'm going to have you raise your right hand as you can and solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury. Do you agree to that, sir?
Yes.
Now, I'm going to bring your attention back to Washington Avenue on Hazel Street in the city of Lansing, Ingham County on June 28, 2023. Were you in the city of Lansing on June 28, 2023 on that date operating a motor vehicle?
Yes.
And at the time you were stopped, did you not have an operator's license on your person?
Yes.
All right. Anything towards a factual basis, Mr. McKee?
No, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, I find the factual basis to be knowing, voluntarily, and accurately made. I will follow the Killebrew agreement as to time served. Anything, any question concerning immediate sentencing, Mr. McKee, or does the city have any objection to immediate sentencing?
No, Your Honor.
Ms. Robinson?
No, Your Honor.
All right. I'm going to
I can't hear y'all.
All right. All right. So we're going to do, you've got a little bit of time. I'm going to do Killebrew time served, which is, so we'll do a Killebrew time served. I have a $75 state fee and a $50 crime victims' rights fee. And then a fine and cost that I'm going to waive in this. So it's $125. I'm assuming your client needs some time to make that payment.
He does.
Yeah.
He doesn't have an out date right now, unfortunately.
Doesn't have an out date right now. Yeah. There's no out date. All right. So we'll administratively close the file.
Thank you.
You're welcome. All right. So Mr. Pruitt, the file for various circumstances has been administratively closed, and you should be all set. Okay, sir?
Okay.
All right. That's all for the record in docket 23-02061. I'm going to go on Dustin Green.
Yes, Your Honor.
So we're on the record in docket 23-01534. That is the City of Lansing versus Dustin Green. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the City of Lansing, practicing under MCR 8.120.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Green. I'm going to be waiving his appearance today. He did check in earlier this morning.
Right. It's my understanding Mr. Green was here earlier today. Mr. McKee, how are we proceeding?
The city would be requesting a 2-week adjournment for compliance purposes, Your Honor.
And that's an accurate statement, Ms. Sutter.
I would say 2 to 3 weeks. He's completing an assessment, and that's being done. That's why we let him go, since he's trying to do it right now. So 2 weeks might be okay. I'm a little worried about the report getting back to me in time.
Yeah. It just seems everybody took August off. So
it's kind of starting to feel that way, isn't it?
It is starting to feel like everybody took August off. I think we did have, so it's going to be a Monday. And I think the 21st is gone and the 28th is gone.
No, we're here on the 21st.
Okay. How about the 14th? Are we here on the 14th?
Nope. Well, we are, but I
We're
can't remember. what's
backed
happening
up.
that day.
You want to try the 21st?
The 14th is the exam. We're running with the fact that
We have 4 co-defendants. This courtroom's not big enough for 4 co-defendants. That's all I know. Okay.
You're right.
That's all I know. Poor Mr. Yang's in the back with his client. I can't even see him.
August 21st at 9?
August 21st at 9?
Thank you.
All right. All right, we'll reset this for August 21st at 9 a.m. for compliance purposes. Anything else for the record? 23-01534, Mr. McKee.
No, Your Honor, thank you.
Ms. Sutter?
No, Your Honor, thank you.
All right, we should be all set. And then let's do Miss Minnie or Minnie James. And I do have an order of fingerprints for Miss James.
Yes, Your Honor, she's aware of that. She tried to go down earlier and I advised her I didn't know there was time for her here.
All
So
right.
she's going to do it as soon as she's done here.
Perfect. All right. So we're on the record in 23-01247. That is the City of Lansing versus Minnie James. Will the parties please introduce themselves for the record? Mr. McKee.
Good morning, Your Honor. Thomas McKee on behalf of the city of Lansing, practicing under MCR 8.120.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing on behalf of Ms. James, who's standing to my right.
And ma'am, you are Minnie James? All right.
Yes, sir.
This is the time set for a City of Lansing pretrial. Mr. McKee, how are we proceeding?
The city would be requesting a 30-day adjournment for compliance purposes, Your Honor.
So let's go with August 21st at 9. Yeah, this is going back a little bit, so we got to get this wrapped up, but we do have failed to appear and there's a prior compliance. But so August 21st is the date, all right, ma'am? All right. Anything else for the record on docket 23-01247, Mr. McKee?
No, Your Honor, thank you.
Ms. Sutter?
No, Your Honor, thank you.
All right, thank you. You're all set. Thank you, ma'am.
Much, I appreciate it.
Yep. And then the order of fingerprints is in the file. Does she need to take that with her? So let me make sure your client has that if she's going today. All right, so Ms. Sutter, if you want to provide that to your client, then she should be all set. Mr. Carter, are you ready on yours?
I would like to be.
All right. Is that Mr. Trevino?
Miss Trevino.
Miss Trevino. Elisa. All right. Miss Trevino. That's a co-defendant case, correct?
Yeah.
All right. All right, so we're on the record in docket 23-02021. That is the City of Lansing versus Elisa Trevino. Will the parties please introduce themselves to the record?
Good morning, Your Honor. Thomas McKee on behalf of the city of Lansing, practicing under MCR 8.120.
And Mr. Carter.
May it please the court, David B. Carter Jr. on behalf of Miss Trevino. I don't know if she's been able to zoom in. She said she was trying to.
She's here, but she's not connected to audio.
She's well aware of my requests.
Okay.
She is pregnant. She was having a hard time with the technology. I would waive her appearance.
All right. I know she can hear us. We just can't hear. She can't. Okay. Well, with her attorney here, I'll leave it to you to provide her what's going on. Okay?
Thank you, Your Honor.
All right.
I've had multiple contact with
All
her,
right.
so she's not somebody that I fear won't get any messages.
Right.
But-
She's here by Zoom. She's just not connected to audio. All right.
And I'll let her know as soon as we're off the record. But I'm new onto the case. I did file my appearance. I haven't had discovery sent to me as of yet.
So
I'm asking for a brief adjournment.
all right. And is there any objection from the city?
No, Your Honor.
All right. So we're gonna. Reset for pretrial. Purposes. We'll reset for discovery purpose for Wendy, what's a good date for that?
Is Mr. Carter available on August 21st at 9:30?
Are you available on August 21st at 9:30?
I will be picking a jury.
So we might go a little further out.
You know, I don't know what your docket's like, but even next week, Monday is fine with me, or following week. Yeah, it's just discovery. It's just
Right. It's
quick report.
so you let me know when you know
The 28th is fine with me. The that date, the 21st, I'm picking a jury.
I think 28th. Everybody's gone on the August, and you're picking a jury. What's up with that, David?
I'm a workaholic.
Yes.
Is Mr. Carter available on August 7th?
August 7th?
Yeah, at 9 o'clock.
All right. Let's do August 7th at 9 o'clock. All right, so this has been reset for August 7th at 9 o'clock. I'll leave, Mr. Carter can advise Ms. Trevino of that date. Anything else for the record in 23-02021, Mr. McKee?
No, Your Honor, thank you.
Mr. Carter?
Just knowing that my client just had a baby, is that okay to appear by Zoom by her?
Absolutely.
I will explain to her about the audio
All right.
issue.
All right.
Thank you.
All right.
She's connected now.
Oh, she is connected now. So, Ms. Trevino, you can hear us? And you might have to unmute yourself.
Yes, I can hear you.
All right, perfect. We've reset this for August 7th at 9 a.m. since your counsel Mr. Carter just filed his appearance. And if you have any questions, you can contact him. But we have that August 7th date at 9 a.m. All right, ma'am?
Okay, thank you.
All right. And that's available by Zoom. That you can make that appearance by Zoom. Okay, ma'am?
Okay.
All right. That's
you.
all for the record. 23-02021.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Mr.
I think I might still be in one of the breakout rooms.
Yeah, you're in room 4. So, Mr. Johnson, we're going to put you in a breakout room, or you should get a prompt to go to room 4 with your public defender. Okay. That's a yes.
Can't hear anything.
Ma'am, on the Samsung, would you please identify yourself?
Melinda Adams.
Melinda Adams. All right. And ma'am, you're here for your 10 o'clock?
Yes.
All right, sir, on the iPhone, would you identify yourself? You're in a car wearing the Nike t-shirt?
Connected audio.
Not connected audio. All right, and then Mr. You're here on the Herman case for the Herman matters. Mr.
That is
you're gonna help
correct.
me. Is it Mr. Wujik?
Wujik, but Wujik is just
Wujik.
fine.
All right, Wujik, and you're here for Mr. Herman. All right.
That
All
is
right,
correct.
we've got a few criminal matters, and we'll give everybody till 10:15 to show up on your cases. All right.
Sounds great. Thank you.
Thank you. All right, so we're on the record in docket 23-02105. That is the City of Lansing versus Tyler Bunkley. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the City of Lansing, practicing under MCR 8.120.
Aaron Robinson, Assistant Public Defender for Mr. Bunkley.
All right, and this is the time set for a pretrial in the City of Lansing matter. This was scheduled for 9 o'clock. It is now 10:04. It would appear that Mr. Bunkley has failed to appear today. Mr. McKee, how would you like to proceed?
Your Honor, the city would request bench warrant bond forfeiture with a 48-hour hold.
Ms. Robinson?
I have no objection to the 48-hour hold.
Okay, so failed to appear for pretrial, bench warrant, bond forfeiture with a 48-hour hold. All right, anything else for the record? 23-021-105, Mr. McKee.
No, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
Thank you. We're all set on that file. And then we're on the record. Is it Mitchell? or McMullen? Aaron, which one is it?
Mitchell.
Mitchell, yeah. All right. So we're on the record in docket 23 L2799311. That's the city of Lansing versus Corey Ale Mitchell. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the city of Lansing, practicing under MCR 8.120.
Aaron Robinson, Assistant Public Defender for Ms. Mitchell.
This is the time set for a city of Lansing free trial. I do not see Corey Ann Mitchell or Corey Ale Mitchell in the Zoom courtroom. There's nobody in the physical courtroom. This was set for 9 o'clock. It is now 10:06. It would appear that the defendants failed to appear for pre-trial. Mr. McKee, how would you like to proceed?
Your Honor, the city would request a bench warrant bond forfeiture with a 48-hour hold.
Any response from Ms. Robinson?
No objection to the 48-hour hold.
Okay, for fail to appear, the court will issue a bench warrant and bond forfeiture with a 48-hour hold. Anything else for the record on the Mitchell file 23 L2799311, Mr. McKee?
No, Your Honor, thank you.
Ms. Robinson?
No, Your Honor, thank you.
Okay, you should be all set on that file.
You guys all my pieces for today.
All right. On the iPhone, would you please identify yourself in the Zoom courtroom?
John Riley.
John Wright.
Riley, R-I-L-E-Y.
John Riley. Okay, you're here for your 10 o'clock?
Yes.
All right. Stand by your right. You're in the right place. I'm just calling some criminal matters before you.
Oh, okay.
So, Mr. Wujek, I'm ready on one of your files. So we're on the record in docket 23-01365. That's Edward Rose Associates versus John Riley. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Ryan Wujek, P84535, filling in for Mr. Herman on behalf of the plaintiff.
All right. And sir, you are John Riley?
Yes, sir. Yes, Your Honor.
All right. And you can hear me all right, Mr. Riley?
Yes, Your Honor.
Thank you. This is the time set. We previously met on June 28th. Parties met in a breakout room. It was adjourned to today's date for a Zoom hearing. Mr. Wujek, how are we proceeding today?
Your Honor, at this time, we are requesting a judgment of possession only. Rent retained based on the books and records of my client of $2,018.94. Cost of $167.79 for a total redemptive amount of $2,186.73. The writ date on that would be August 3rd, 2023.
All right, so the request is for a possession judgment. Mr. Riley, we're putting the cart before the horse a little bit. Mr. Riley, do you have any objection to the request for possession judgment in this matter? This is the second hearing. I'm assuming we set this for second hearing to see if there was some, I don't know if this was a default. So why did we set it for second hearing, Mr. Wujek?
Your Honor, based on my notes, I show that there was no dispute in this matter. I don't know if it was adjourned upon agreement of the parties. Of course, the amount that was agreed to was only through June. This matter now includes July, and there have been some payments. I don't know if there's a dispute as to the amount that Mr. Riley is alleging. If so, we can, absolutely go from there and see where the disconnect is.
All right, Mr. Riley, did you, just so everybody's on the same page, Mr. Wujek, can I put you in a breakout room, Mr. Riley, and you can make sure all the numbers are set?
Yeah, I'm happy to do so. Of course.
Mr. Riley, would you be amenable to meeting Mr. Wujek in a breakout room just to make sure all the numbers are set? Since the last time it was June 28th and it's now July 24th, I just want to make sure we all have everything set.
Okay.
All right. So I'm going to have Mr. Wujek and Mr. Riley placed in a breakout room, and then we can come back and place whatever came out of that on the record.
Great. Thank you.
Thank you.
My name is James Lear, sir. Last name Lincoln, Edward Yankee, one way off the one. Thank you, sir.
That's a ticket. Thanks. So you, Mr. Lair?
Yes, sir.
All right. We just bench warranted you.
Well, I was told to sit there and I'll be on Zoom, sir. Forgive me for interrupting you, but
you're fine. Stay there. We're going to withdraw it because it was placed on a 48-hour hold.
Thank you.
Yeah, and so and then if you want to talk to the city attorney about these two files, we can set that up. Okay.
Yes, sir.
All right. So you should be fine. One of the city attorneys will meet with you, and we'll call your case.
Sit down, sir.
Yeah.
Thank you, sir.
You're good. Mr. McKee, were you going to meet with him?
Actually,
So
if you don't mind, Your Honor, he just checked with me outside in the hallway, and I was going to come in and ask. Aaron Robinson is his attorney.
Aaron Robinson is his attorney.
According to our system.
Yeah, we have he applied, but we didn't have anything on that.
I'm James Lear. My
All
brother
right.
John's in trouble too, I guess.
No, not currently. I see two layers. So.
Yeah.
All right. So let's have Miss Robinson, I think, thought she was done.
Yes, I think so. So I will speak with Mr.
All right. So talk with Miss Sutter from the Public Defender's Office, and then she can talk with Miss Williams and Miss
Yes, sir.
McKee. All right.
Ms. Sutter, when was Ms. Robinson appointed, please?
Well, here's the thing, Wendy. Cornish has a note that says, please file an appearance. I don't see a note that says appearance filed, so I'll put that note in.
All right.
Okay.
Oh, you're supposed to fill out the paperwork, I think. I mean, I was, and I didn't really, I'm not guy, like, if you.
Oh, this isn't a you. This is the clerk in our office for this. No, that's okay. You're good. This is one of our clerks. I'll have that sent over to you.
Thank you, Ms. Simon.
Yes, yes.
Mr. Wujic's, we can probably call Mr. Wujic's back.
We've come to an agreement on this matter.
All right, let me go ahead and bring back Mr. Riley. Should be on his way. All right. So we're back on the record in 23-01365. And Mr. Wujic, you've had the opportunity to speak with Mr. Riley in a breakout room?
That is correct, Your Honor. I did have a chance to discuss the numbers and outcome with Mr. Riley, and the parties have agreed to a consent judgment of possession only. Be happy to place those terms on the record.
Okay, you can proceed.
Thank you. Again, this is a consent judgment of possession only. The numbers are agreed to be $2,018.94 in rent, cost of $167.79, for a total of $2,186.73. The writ date is going to be August 3rd, 2023. Defendant thinks he can get that paid up by then. And just so the court is aware, the defendant did make a payment of approximately $600 over the weekend. We did discuss he will be credited that amount towards the judgment. It's not included. But of course, I don't have those records since the payment hasn't processed yet. I did advise the defendant of his MCR 4.201I rights, and I forgot to ask for permission to sign, but I would like to ask him for permission to sign so we can submit that.
Yeah, go
You
ahead.
may proceed, Mr. Wujic. So, Mr. Riley, was anything indicated on the record that was not discussed in the breakout room?
No.
All right. And you understand, Mr. Riley, that Mr. Wujic's asking for your permission to advance to the court any paperwork that has previously been discussed. Does he have your authorization to sign sign those documents?
Yes, Your Honor.
All right. All right. And you also understand, pursuant to the court rule, that you have 3 days to file a motion. If somehow this is ambiguous or you do not understand the consent judgment, it's my understanding. This looks pretty straightforward, that there is a certain amount that's been discussed and a writ date of August 3rd. Is that correct?
Yes, Your Honor.
All right. So, Mr. Wujic, you'll advance the paperwork?
That is correct. Mr. Herman's office will file the judgments today.
Okay. All right. Anything else for the record, docket 23-01365, Mr. Wujic?
No, Your Honor. Thank you.
Mr. Riley, do you have any questions of me?
No, Your Honor.
All right. You should be all set. Thank you for your appearance today on that file.
Thank you.
All right, thank you.
Mr. Dowrick, you're here on Miss Jones?
Yes, sir.
Is that correct?
Yes,
All right.
sir.
Let's go ahead and call that case. So we're on the record in docket 23-00932. That's Todd Dowrick versus Latia Jones. Will the parties please introduce themselves for the record, Mr. Dowrick?
Todd Dowrick.
All right. And this is the time set for a this is set out for date for a landlord-tenant matter, for a second hearing or a control date on the matter. I do not see a Latia Jones in the Zoom courtroom. I do not see Latia Jones in the present courtroom. Nathaniel, you want to check just to see if Letitia Jones is somewhere outside? We're going to check the hallway. Mr. Dowrick, did you expect to see Miss Jones today?
I don't believe she's coming.
All right, we'll check the hallway and then we'll indicate this was scheduled for 10 o'clock. It is now 10:24. It would appear that Lieutenant Letitia Jones has failed to appear for hearing. And Mr. Dowrick, how would you like to proceed?
I would like to request a default judgment, please.
All right. Are there any numbers you wanted to place on the record, Mr. Dowrick?
Yes, sir.
All right.
The possession judgment would be $226 plus the court costs of $162.16 for a total of $388.16. The money judgment would be $50 plus the court costs of $162.16 for a total of $212.16 with a writ date of August 3rd of 23.
I can't do, you're gonna have to sever, hold on. Let me double check this 1, 2,
Okay.
6, 7, let's see, the 31st, 7, 8, 9. So that August 3rd date is the writ date, right? And then we have he did serve her personally. Okay, I have personal service.
Okay.
And then I have, so the money judgment works with personal service. We do have parties met and received this hearing date that has failed to appear, but we do have personal service on the file. So, so if you advance the order to the court, I will look at it and sign it. And if I have any questions, I'll contact you. Okay, Mr. Dowrick?
Thank you very much.
All right, that's all for the record in docket 23-00932. Mr. Dowrick, you should be all set.
Thank you.
You want to go on Lehrer?
Yes.
Or Johnson? You have.
We already, I think we're waiting for an answer on Johnson.
Okay.
We have Lehrer ready as well as Mr. Mitchell, or I'm sorry, Mr. Richards. Reading one name, saying another.
Yeah, we did call Richards already, but if he's here, let's pull back.
Oh, I must not have been here because he is assigned to me.
All right.
So I apologize, I must not have been.
We don't have an appearance line.
I'll have one file.
Here, so give me the Richards file, the same that we did. All right. All right.
Do you know when you were appointed, ma'am? It's like that's another one either. Okay, so I'm not losing my mind.
Right,
Your
right,
office is
okay.
struggling. Okay. Yeah. Oh.
So D appeared. So I'm gonna put D appeared. No.
He's here.
Which one?
Richard?
He's here.
Yes, he's here. He's been here for a while. Apparently, the desk staff told him to sit outside in the hallway. So
We'll just start checking the hallway a little bit because I think they're saying that or what, but
yeah,
I think, all right, so let's call Lehrer. No, let's call Mr. Lehrer.
Thank you.
So we're on the record in docket 23-01914 and 23 L279451. That is the City of Lansing versus James Lehrer. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the City of Lansing, practicing under MCR 8.120.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Lehrer, who is standing to my right.
And sir, you are James Lehrer?
Yes, sir.
All right. This is the time set for a City of Lansing pretrial. I'm going to indicate for the record so there's no ambiguity. We had previously the defendant failed to appear. We should have bench warrant bond forfeiture with a 48-hour hold. There was some confusion as to representation. Defendant did appear, so he's here. I've indicated on the ROA that the bench warrant's dismissed, so you don't have to worry about that, and that you are represented by the public defender's office. All right. So hopefully that clears up any ambiguity in the file, Mr. McKee, in either file or extending ticket. Mr. McKee, how are we proceeding today?
Your Honor, it's my understanding that Mr. Lair would be accepting responsibility for an amended first charge of impeding traffic, and the second charge is issued.
So the first, it would be an amended. This both comes from a ticket, I think.
Yeah, so the misdemeanor charge would be amended to the civil infraction,
Okay.
and then he would be accepting responsibility for the second ticket as well.
So we amend the misdemeanor to no ops. I'm sorry, to impeding traffic, and that is, what's that code?
MCL 257.676B.
676B. And what is that? $130 fine?
Yes.
And then he'll also be accepting responsibility to the civil infraction of disobeying a traffic signal.
Yes.
All right, and
I believe that is also.
that's also 130. All right. All right, so Ms. Sutter, that's your understanding. The misdemeanor is to be amended to the impeding traffic with a $130 fine, and also the civil infraction that was written at the time, which was the traffic signal ticket, is also going to be admitted responsibility, and the misdemeanor is going to be dismissed. Is that your understanding?
That's correct, Your Honor, and I will be accepting responsibility on my client's behalf.
All right, perfect. All right, and both civil infractions carry a $130 fine. So I'm going to bring you back just to make sure we're working from the same ticket. It's in the city of Lansing on June 13, 2023, at the civil infraction venue of the city of Lansing, Ingham County. Your client, on behalf of your client, accept responsibility to impeding traffic pursuant to 257.676B.
Yes, Your Honor.
And you accept responsibility for the disobeying a traffic control device or a traffic sign on that date.
Yes, Your Honor.
All right. With that understanding, the court accepts the admission of responsibility on the civil infraction. And do you need it's $130 on each civil infraction. Does your client need some time?
Yes, Your Honor. Could you give him 60 days?
Sure.
Thank you.
All right. So, Mr. Lair, you have till September 22nd to pay each one of these fines. It's $260 altogether. How this works, if it helps, is as long as it's all paid up by September 22nd, you can go and give whatever amount of money you want per time. So you can kind of set up your own plan. Okay.
I'll get paid, Your Honor.
All right.
Yes, sir.
But as long as it's all done by September 22nd, we're good. All right, sir?
Yes, sir.
All right. Anything else for the record?
If I get community service, I'll shine your shoes for the next 2 years, all right?
I think you're stuck with the payment. Okay.
Yes, sir. Thank you,
All
sir.
right. Anything else for the record? 23019114, Mr. McKee.
Nothing further.
All right, Ms. Sutter, are we all set?
We're all set, Your Honor.
All right,
Thank you.
Mr. Lair, good luck to you. Thank you.
Have a good day, sir.
You too.
Yes, sir. Hey, thank you, ma'am.
You're welcome. Have a good one.
Let's do Richards. So just to make sure. All right, so. Right. So we're on the record in docket 23 L27866632. Parties appearances for the record, Mr. McKee.
Good morning, Your Honor. Thomas McKee on behalf of the city of Lansing, practicing your MCR 8.120.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Richards, who is standing to my right.
And sir, you are Robbie Richards? Yes, this is the time set for a City of Lansing pretrial. I will indicate, so there's no problems with the file, that that we have it as defendant failed to appear previously, and a bench warrant bond forfeiture were put on. There was some ambiguity concerning appointment in the court file, but now we're here. Any bench warrant's been dismissed or has been pulled out, de-appeared, and is represented by the public defender's office by Ms. Sutter. So, Mr. McKee, how are we going forward today?
Your Honor, the city would be requesting a 45-day adjournment for compliance purposes.
Is that your understanding, Ms. Sutter?
It is, Your Honor.
What's a good day? I think that puts us past all our craziness, doesn't it?
Someone can feel the breakout room.
How does 9/11 sound? At 9 a.m. August is definitely the problem scheduling. So let's set it for 9/11 at 9 a.m. Okay.
Thank you.
All right, Ms. Richards, please keep in contact with your attorney, Ms. Sutter. We've adjourned this out to September 11th at 9 a.m. Okay, sir. All right. Anything else for the record in the ticket 23 L27866632, Mr. McKee?
Nothing further, Your Honor.
Ms. Sutter?
Nothing further.
All right, you're all set. Thank you. Thank you for your appearance today.
Maury Adams, no, I sent him to a breakout room. He's joining us.
Okay. Mr. Adams, you should go to the breakout room, room 1, with Mr. Wujek. There you go. And then, Miss Adams, we'll call your case as soon as Mr. Wujek is out of his breakout room. All right, ma'am?
Okay, thank you.
You're welcome. Ms. Mannon, are you ready to go forward on Mr. Akanicki's case of David Buch and Olivia Tedder and Paul Benavides?
Yes, Your Honor.
All right. So we're on the record in docket 23-01466. That is David Buch LLC versus Olivia Tedder and Paul Benavides. Will the parties please introduce themselves for the record?
Cindy Mannon, standing in for Robert Akanicki, who represents David Buch LLC.
All right, and this is the time set for a second hearing. We met previously on July 5th, 2023, where Olivia Tedder, Paul Benavides did not appear at that previous hearing. We did have service by attachment, so we set it for second formal hearing today on this date, it would appear that Ms. Tedder and Mr. Benavides once again have not appeared. This was scheduled for 10:15. It is now 10:39. And they have failed to appear to the second hearing. So Ms. Mannon, how would you like to proceed today?
Your Honor, I have in my hands a judgment, a default judgment. And Mr. Akanicki informed me that he emailed this judgment to the court this morning for your signature.
All right. Did you want to put any numbers on the record, or are you?
I can.
Okay. Why don't you go and put the numbers on the record, and then we'll make sure it's the same judgment.
Thank you, Your Honor. The rent to retain possession is $3,400. The cost, $210. Total amount, $3,610. Writ would issue on August 2nd.
So it's August 3rd now. So I'll make that change on. I'll make that change on the document.
Thank you, Your Honor.
All right. So I will sign that document when I get it on my desk. Anything else for the record in 2301466, Ms. Mannon?
No, Your Honor. Thank you very much.
All right, thank you. You should be all set.
Thank you, sir.
Your Honor, maybe back into a breakout room with Mr. Johnson.
Sure.
Thank you. I'm back in the waiting room.
Where are you? Where are you?
I'm in the
Lauren?
waiting room.
You're in the waiting room?
Yeah, I got booted from the breakout room, which caused that noise issue, so I just left the meeting.
So let's put you both in room 2.
Thank you.
When do you have to make you a? Do I have to make you a
Yeah,
co-host? All right.
There's power.
I'm giving you power right now. And Mr. Johnson, you should go to room 2 with Ms. Sutter in order. Okay. So, Mr. Dell, you're here on your 10:30?
Yes.
All right. And we're waiting on a Raynell Atchison, another 5 minutes.
Okay. Thank you.
All right. You're welcome. All right, Mr. Wujik, we're on the record in docket 2301-373. That's Edward Rose and Associates versus Lamari Adams. Will the parties please introduce themselves for the record? Mr. Wujik.
Good morning again, Your Honor. Thank you for granting me that time to speak to the defendant, Ryan Wojcik, P84535, on behalf of the plaintiff.
And sir, you are Lamari Adams?
Yes, sir.
All right. This is the time set for a landlord-tenant free trial scheduled today. And Mr. Wujik, you, as indicated, you did have the opportunity to speak with Mr. Adams in a breakout room. Mr. Wujik, how are we proceeding?
Your Honor, I did have a chance to speak with Mr. Adams. The parties have agreed to a consent judgment of possession only. I'd be happy to place those terms on the record.
All right. You may proceed, sir.
Thank you. Again, consent judgment of possession only. On the judgment, we're going to put rent to retain of $999.21, cost of $167.79, for a total redemptive amount of $1,167 even. The writ date would be August 3rd, 2023. For the record, Mr. Adams did make payment over the weekend. He stated he made payment over the weekend. He will be credited that amount towards the judgment amount, but we do not have those records just yet. I also did advise him of his MCR 4.201I rights and have permission to sign his name to a consent judgment to that effect.
And Mr. Adams, was there anything that Mr. Wojcik just indicated came out of the meeting that was different than you and he had discussed?
No.
All right. And you have given Mr. Wujik authorization to sign on your behalf any consent judgment that we've discussed on the record to this court, and the MCR was explained to you. Is that correct?
Yes.
All right. And just to reiterate that MCR, what that indicates is you're not represented by counsel today. So you have 3 days from today's date to file a motion indicating that something about the consent judgment was either ambiguous or you didn't understand the nature of what you signed. Do you understand that, sir?
Yes, sir.
All right. All right. With that understanding, the court will await the order. The order to follow. Anything else for the record in docket 2301-373, Mr. Wujik?
No, Your Honor, we will file that order as soon as possible.
All right. Thank you. You have any questions of me, Mr. Adams?
Yeah, okay. So once I pay that, it's done, right?
It's got to be done. It's got to be paid by August 3rd. Is that correct, Mr. Wujik? That's the vacate
That
date?
is correct, Your Honor.
Yep. But once that's signed, once that's paid, then Mr. Wujik will advance this case will be over. It'll advance. So the consent judgment will be set.
Okay.
So it's got to be paid. That number's got to be paid by August 3rd.
Yes, sir.
All right. Any other questions, Mr. Adams?
No, sir.
All right. That's all for the record in 2301-373. Mr. Adams, you're free to leave the Zoom courtroom.
All right. Have a great day.
You too. And Mr. Wujik, did you need to speak with Miss Adams before we call that case?
I did speak with Ms. Adams already. She's been
Okay.
incredibly patient. Thank you.
All right. So let's go ahead and call that case. So we're on the record in 23-01369. That's Edward Rose and Associates versus Melinda Adams. Will the parties please introduce themselves for the record?
Good morning again, Your
Melinda
Honor.
Adams. Sorry.
And Ryan Wojcik for the plaintiff.
That's all right.
Nope.
All right. And ma'am, you are Melinda Adams, that's correct?
Yes, sir.
All right, and you can hear me all right, Miss Adams?
Yes, Your Honor.
All right, this is the time set for a landlord-tenant pretrial. I'll indicate that the parties previously met on June 28th, and a second hearing was set on today's date. Mr. Wujik, how are we proceeding today?
Your Honor, I did have a chance to speak with Ms. Adams, and the parties have agreed to a consent judgment of possession only. Would be happy to place those terms on the record.
Yes, please, Mr. Wujik.
Sorry, thank you. Again, we did have a chance to discuss. The consent judgment reads rent to retain of $1,748.16 in rent, cost of $167.79 for a total redemptive amount of $1,915.95. Again, in this matter, I did speak with Ms. Adams. She states that she made a payment of $990 over the weekend. She will be credited that amount, but since we have not confirmed that, we are not including that in the judgment amount. The writ date would be August 3rd, 2023. I did advise the defendant of her MCR 4.201I rights and have permission to sign her name to a consent judgment to that effect.
All right, and Ms. Adams, was anything said on the record by Mr. Wujik that was not a part of your agreement or what you discussed, previously discussed?
No, Your Honor.
All right, I'll indicate that, and you've authorized Mr. Wujik to sign any documentation concerning that consent judgment that's been previously talked about to the court for the court to sign. You're good with him doing that? You've given authorization to do that based on the numbers that have been placed on the record?
Yes, Your Honor.
All right, and also the MCR was explained to you, and I will go through that for the record purposes, that you have 3 days from today's date to indicate that there's something in this consent judgment that you did not understand or was ambiguous to you. Other than that, it seems pretty clear to me that the payment or the writ date of August 3rd, but you understand that's been explained to you. Is that correct?
Yes, sir.
Okay, I will indicate that the order is to follow. Anything else for the record in docket 2301-369, Mr. Wujik?
No, Your Honor. Thank you.
Ms. Adams, do you have any questions of me?
No, I don't. Thank you.
All right, thank you. That's all for the record in 2301-369. And then, Mr. Wujik, I think that concludes your case today. Is that correct?
That's what my records show. Thank you very much for having me this morning, and have a great rest of your week.
You too, thank you. And Ms. Adams, you're all set. Thank you for your appearance. You can leave the Zoom courtroom.
Okay, thank you.
Then we'll call, which criminal cases are ready?
Johnson.
Johnson.
That's all I have left.
Yeah, it's the last one.
It's the left. What about McMullen?
Oh, yeah, that's right.
Oh,
Yeah, you're right.
you know what?
I haven't
Yeah.
seen him this morning.
It is on my list.
Let's do Johnson.
Okay.
I know Mr. Johnson's been here
Yes,
and he's here. All right.
I
So-
will say it looks like Mr. McMullen called my office this
Okay.
morning and asked for a call back. Obviously, I haven't done that yet. That
Right.
happened-
Obviously, that's hard to do.
Yeah.
All right, so we're on the record in 2302-022. That's the City of Lansing versus Nathaniel Johnson. Will the parties please introduce themselves to the record?
Good morning, Your Honor. Thomas McKee on behalf of the City of Lansing, practicing under MCR 8.120.
And Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Johnson, who is appearing via Zoom.
And sir, you are Nathaniel Johnson?
Yes, sir.
Okay, and you can hear me all right, Mr. Johnson?
I can.
All right. Good. So this is the time set for City of Lansing pretrial. Mr. McKee, how are we proceeding?
Your Honor, the city would request a 1-week adjournment for ongoing negotiations.
That's correct, Your Honor.
All right, for negotiations. So we will set, is the 31st available?
Yes.
All right, we'll set it for July 31st. It's not August, so that's a big deal, okay? Evidently, July 31st at 9 a.m. All right, so Mr. Johnson, this has been reset for next Monday at 9 a.m., July 31st. And then we'll see at that time. Zoom is you can appear by Zoom at that. Okay.
Yes, sir.
All right. Anything else for the record? 23-02022, Mr. McKee.
Nothing further, Your Honor.
Ms. Sutter?
Nothing further, thank you.
All right, Mr. Johnson, you're all set. Thank you for your appearance today.
Yes, thank you.
And then let's go ahead and call Mr. McMullen. We can put that on the record.
If you don't mind, he apparently just called my office
Do you want to
2 or 3
call him?
minutes ago. Do you mind?
No.
Yeah, if I can get him here, I might as well.
We've got a few cases.
Thank you.
Mr. Brown, I think we're ready on, is that Jared Dell and Renell Atchison? No, I'm sorry. Mr. Brown, yours is Tierra Wright. Is that correct?
That's correct, Your Honor.
I got a couple cases. All right, so we're on the record in 23-01510. It's Shiawassee Apartments versus Tierra Wright. Will the parties please introduce themselves for the record?
Yes, good morning. Chris Brown representing plaintiff.
And this is the time set for a second hearing. We initially were together on July 5th, 2023, in which Ms. Wright failed to appear at that pretrial. We had service by attachment, so we set it for second hearing. I do not see a Tierra Wright in the Zoom courtroom. There's nobody in the physical courtroom. Then you might want to check on the corridor, just because people have been showing up today and they're hiding from us.
Understood.
Yeah. They're out on benches that are not even associated with this courtroom. Okay. So with that understanding, Ms. Wright is not in the hallway. It would appear that Ms. Wright has failed to appear for the second hearing. Mr. Brown, how would you like to proceed?
Requesting a default be entered for non-appearance, and I'll submit that to the court here shortly.
Okay.
Possession only.
All right, the order to follow. Anything else for the record in 23-01510, Mr. Brown?
Nothing at all. Thank you.
Okay, you should be all set. Thank you for your appearance today.
Thank you, sir.
And then Mr. Dell.
Yes.
Okay, we're here on the record in docket 23-01699. That is Jared Dell versus Raynell Atchison. Will the parties please introduce themselves for the record? Mr. Dell.
Yes, Jared Dell, residing in St. Clair Shores, owner of the property, 505 South Pennsylvania.
This is the set for 10:30 today. It is now 11:01. The history of this case is indicated that it was scheduled, we met on July 5th, 2023. It would appear that Ms. Atchison failed to appear on that date. We had service by attachment. And so we set it for second hearing on this date. It would appear that Ms. Atchison has once again failed to appear. I've checked the Zoom courtroom, the physical courtroom, and the hallway, and Ms. Atchison is not here for second hearing. I'm assuming, Mr. Dell, you're requesting a default judgment for non-appearance?
Yes, Your Honor.
All right. Do you have any numbers that you wanted to place on the record, Mr. Dell?
The previous numbers, judgment, $4,255.46. To stay would be $4,692.96.
Okay, our writ date for today's purposes is August 3rd. Understand that anything you forward to the court for the court's signature, ruling an order to that effect, it'll be 10 days from when the court signs it. So if I sign it today, it would be August 3rd. If I send it tomorrow, it would be August 4th.
Okay.
Right. And okay. So you did file for money judgment, but you're going to have to sever that and set that separately because Ms. Atchison was never personally served. So I'm not able to give you any money judgment you can collect on it any way you want but you're gonna have to get her served on that collection, on that money judgment. I can give you possession judgment and arrearages and rents.
Okay.
So if you submit an order to me, this is where Zoom gets a little complicated. If you submit an order to me to that effect, or why don't you submit an order to me to that effect? And what I'll do, I'll review it. And if I have any questions, do I have a contact number to contact you at, just so if we have to change it at all, or so you know what we're doing? Do you have a contact number?
Of course. My phone number is 586-709-7480.
Okay. All right, go ahead and submit an order. I'll take a look at it. And then if I make any changes, drastic changes, I'll give you a call. If not, I'll sign it. I'll make whatever small changes are necessary, like the writ date and the appeal date. And we'll go forward from there. Make sure you submit an order, because if you don't, we're gonna get a note to dismiss your case because for untimeliness. So make sure you submit an order, okay, sir?
Okay, will do.
All right. Anything else for the record in 2301-699, Mr. Dell?
No, sir.
All right, you should be all set. Thank you for your appearance today.
Thank you. Bye-bye.
All right, I indicated that was the Zoom hearing. So we're on the record in docket 22-03279. That is City of Lansing versus Dylan Michael Schramm, set for show cause in regards to an outstanding debt. So show cause to the City of Lansing on an outstanding debt of $963.52. It would appear that defendants failed to appear at show cause, but it appears that the defendant may be incarcerated in the Eaton County Jail. And so we're going to adjourn this show cause hearing to August 21st at 11 o'clock. And then we'll address the outstanding debt to the City of Lansing. We'll adjourn this show cause to August 21st at 11 o'clock. That's all for the record in 22-03279. And then we're on the record in docket. I don't have a file on spot, but I
No,
don't.
because it's in my.
All right. So we're on the record in docket 22-00277. That is City of Lansing versus Anthony Swathwood. This is the time set for a bond show cause. It would appear that this was scheduled for 11 o'clock. It is now 11:18. And Anthony Swathwood is not in the Zoom courtroom. He's not in the physical courtroom. So Anthony Swathwood has failed to appear for the show cause. So the court will issue a bench warrant and bond forfeiture for the fail to appear for show cause on this date.
We actually need to. Hold the binding agency captain, which is what the hearing was.
All right, so the bonding agency has also failed to appear for today's hearing. And so the bond is to be released to the City of Lansing. So that's all for the record in 22-00277.